Welcome to our Law for Community Workers series, wrapping up what's new in the law in 2024. My name is Natalie, and in this episode I'm talking to Cailey, a family lawyer at Legal Aid New South Wales, about what's new in family law. Before we start, I would like to acknowledge the traditional custodians of the lands we are recording on today and pay our respects to elders past and present. Just a reminder that this podcast is general information only and cannot be relied on as legal advice. The information is correct at the time of publishing, but it may change. If you need help about a particular situation, contact our team at Law Access New South Wales via web chat through the Legal Aid New South Wales website or call 1300 888 529. Thanks, and let's get started. So, what changes have there been in 2024 in family law in Australia that you think are important for people to know about?
Two really big ones and then one niche one. The biggest one would be the amendments to the Family Law Act in relation to parenting arrangements, and that started back in May 2024 of this year. The second biggest one is sort of keep an eye and an ear out for this, which is some changes to property settlement and the way the court looks at dividing assets of relationships. And the third one, which is a really niche one, is really about births, deaths and marriages in New South Wales and changes to how parents can ultimately change their child's name. They'd probably be the three ones that come to mind for this year, 2024.
Yeah, thanks, Cailey. Maybe let's start with the changes to births, deaths and marriages, because that's something people might not have heard about as much, and I'm interested to hear more about that. So maybe start with explaining that change.
Yeah, of course. So I think the easiest way to do it is to tell you what it was before. So before this change came into effect, if someone wanted to change a child's name, they had to get this really specific court order, one, approving the proposed name change, and two, authorizing that parent to basically apply without the other parent's consent. So quite technical, pretty arduous. Today, after the changes, we have seen their ability to change a child's name if you've got an order for a sole parental responsibility order, much, much easier. So you don't have to, no longer do I have to give people advice that they have to go back to court if they've got a sole parental responsibility order. So for those people, ultimately that legal change just makes that a little bit easier for them to change their child's name.
That does sound like a very practical and helpful change for a lot of people. So, throughout the year, I think people probably have heard bits and pieces about the parenting amendments. What changes in parenting stick out to you the most?
Two big ones. So, the first big one, especially for community workers to get an understanding of, is how the court has changed what they consider in a child's best interest to know what court orders ultimately to make for kids. So, there used to be 15 considerations. They've culled that back to only 5 considerations. And then there is an additional one for Aboriginal and Torres Strait Islander children regarding their right to enjoy, connect with, maintain, explore, and develop this positive appreciation for their culture. The second biggest change would be the court's approach to this concept that we call parental responsibility, or in the new legislation's words, it's called decision making responsibility. And basically, that's where there was this presumption in the old legislation that parents shared equal shared parental responsibility. So making decisions, long-term major decisions rather, for their children, things like what's their school that they should go to, signing off on medical treatment, what religion they practice, all those big things. And this legislation has removed that presumption. And in doing so, it's also removed this long-standing pathway that the court used to have to follow. So they used to have to, if you were making an equal shared parental responsibility order, consider first looking at whether it was the best interest of a child for equal time to occur. And then if you said no to that, whether it was in the best interest of the child for substantial and significant time. So it's removed the requirement for the court to go down that pathway, which is huge.
So, Cailey, family violence has been a big and concerning topic, well, always, but certainly in 2024. So, how has the family law jurisdiction responded to this?
In a number of ways. The parenting amendments that we saw back in May 2024 start definitely recognise and definitely emphasise the impact of family violence on children and carers. We see the court, as a result of this, arguably more equipped to respond to domestic and family violence in their case management and also ensure that the parties and the children going throughout court proceedings are safe. We've also seen some administrative, I suppose you would call them, changes. So there's legislation now that allows the court easier access to information about things like child abuse, family violence from welfare agencies, police, those types of departments, which ultimately I would say puts the court in a better position to make informed findings of risk much, much quicker. And then, very recently, as I mentioned earlier, is this new introduction of the Family Law Amendment Bill that was passed in November 2024. We won't see these changes come into legal effect until, I would say, about early to mid next year, 2025. But these changes definitely recognise the economic impact of family violence on separated parties and children as well. And I think if I could touch on this a little bit further, the sort of three biggest things that I've picked out that I think community workers should know about here is one, there is now going to be in the legislation this express recognition of economic and financial abuse as family violence. And the new legislation, ultimately, in its current form anyway, will give us a definition and provide us with some examples of that as well. So things like controlling access to money, sabotaging income employment, accumulating debt, for example, without their consent, those types of things. It also codifies what currently is in case law only, this really important principle that recognizes family violence is absolutely a factor that we need to consider when determining how assets and debts should be divided, and absolutely something that can impact on a party's ability to contribute during a relationship, and also impact on someone's economic future. So, real consequences that we've seen there, and this new legislation will particularise that in the legislation and recognise that, which I think is huge. And the very, very last one, we always used to have to give advice to parties that animals were just going to be divided as part of the normal asset pool. Whereas now the new legislation proposes to have this new approach. In the legislation, it speaks about companion animals, in my terms, household pets. And basically, it allows the court more powers, I suppose, to be able to deal with animals in new light. So, really considering things like the circumstances in which the animal was acquired, any domestic or family violence as a part of that relationship, and the need for that animal to be with one person over the other. If there has been a history of actual or threatened sort of cruelty or abuse towards that particular animal. So, really, again, just equipping the court with more tools, I suppose, to be able to really focus in on and recognize how family violence has a huge impact economically, not just on parenting arrangements.
Thanks, Cailey. That is a really good change to hear about. I know a lot of people, pets are such a huge part of their lives. And funnily enough, while you were talking about that, my dog was in the background scratching the carpet. I don't know if you could hear that. So she
I couldn't.
agrees. Pets are not purely property.
I agree with her.
All right. Well, thank you so much for your time today. I think that was a really helpful wrap up of what's changed in family law in Australia in 2024.
You're welcome. Thanks for having me.
I know family lawyers in legal aid often give advice to people on things like AVOs, the new coercive control laws, and we will be talking about those with our criminal lawyers in another podcast. That's all for this episode. Thank you again to Cailey for chatting with us. You can check out our other episodes in this series, wrapping up what's new in civil law and criminal law. We'll put the links to those and more in the show notes. Bye for now.